And after further briefings on these issues, beginning on July 10th, it will be manifest that the trial result cannot stand. Oh, that's good. The court's decision will be rendered off calendar on September 6th, and the matter is adjourned to September 18th, 2024 at 10 a.m. for the imposition of a sentence, if such is still necessary, or other proceedings. Oh, man!
Right, this is a president who has talked about absolutely using the Justice Department to go after his rivals. This explicitly immunizes anything the president wants to do through the Justice Department, but all but explicitly justifies anything the president wants to do, full stop, to anyone.
Alvin Bragg's in big trouble. So is Judge Merchan and the rest of the Democrats. They really wanted Trump to be sentenced so that they could call him officially a felon. But that's not going to happen anytime soon. Maybe not at all. Judge Merchan is even saying that. We'll see if this even has to happen now that the Supreme Court has said Trump is entitled to at least some immunity. And Judge Merchan didn't go through that inquiry at the start of the trial. So we're going to talk about what's going on here, because Trump submitted his challenge to the conviction saying, you done goofed here, Judge. The government responded, said, we're going to need a lot of time to investigate this. And Judge Merchan agreed. And there's some very particular language in there that's going to matter bigly. So let's go through some of the filings and see what happened before we get to the judge's official ruling. This came out right after the Supreme Court from the Trump team. Remember that this judge, Judge Merchan, who donated to Joe Biden twice and whose daughter works for Joe Biden and does fundraising for him, made $93 million for the Democrats, all the things. Trump submitted a motion to him that was asking him to consider immunity. And the judge said, immunity does not apply to you. And when Trump appealed that, they also said it doesn't apply to you. Okay, so Trump has already brought this up. It was already denied. So that is etched into the record. So we can refer back to that and say, oh, remember when we asked you about that and you said no? You should have said yes. You screwed up, Judge. So now they're coming back. They say, all right, Your Honor. Well, nice to see you again. We respectfully submit this pre-motion letter, and this judge doesn't want actual filings from anybody. He just wants one page. He says, write a pre-motion before you submit an actual motion, because he doesn't want Trump to muck up the public record with the truth. So he keeps all of that buried. And so as we see here before, Trump now puts margins all the way to the very end to squeeze as much as he can onto a single sheet. He's like, oh, I get one page? Okay, how about we do 0.333 margins? So Trump is now submitting this to the judge. He says, listen, Your Honor, we're submitting this pre-motion letter seeking leave to set aside the jury's verdicts because they're illegitimate, pursuant to New York law. And that's based on the decision today that came out from the Supreme Court. Now, as explained below, Judge Merchan, the Trump decision from the SCOTUS confirmed the defense position that we already tried to tell you, that Alvin Bragg should not have been permitted to offer evidence of trial of Trump's official acts. We done told you already, but you didn't listen. Now, we respectfully request until, and this is like a big thing, all right? They're saying you should not have been permitted. We told you no. You said yes. We said absolutely not. You said absolutely yes. It's on the record. There's tons of filings. We read them. And so since you were wrong, we respectfully request until July 10th to submit a memorandum of law in support of this motion. Because of the complexity of the issues presented, President Trump does not object to an adjournment of the July 11th sentencing date, which was scheduled right around the corner, in order to allow adequate time for a full briefing, for oral arguments, and for a decision from you, Judge, because we need to get into this. So here's the background, just in case you forgot. By way of background, on March 7th, 2023, some months ago, President Trump filed a motion in limine, which is a preliminary type of motion to preclude evidence before the trial ever started, to say this cannot come in, and we have to keep out specifically official acts, and it was based on the presidential immunity doctrine. Do you know why? Oh yeah, because we were talking about that in the Judge Chutkan case in Washington, D.C., knowing that this was going up on appeal. Now, in that filing, which we told you, Judge, we objected to anticipated testimony from certain potential government witnesses, evidence of President Trump's social media posts and his public statements. None of that should have come in because it was official. And a 2018 filing with the Office of Government Ethics, all of these little bits of evidence. Witnesses might comment on official stuff. Trump's social media posts might reference official stuff. Public statements clearly official. 2018, he was the president. So we also requested an adjournment of the trial. So we told you, first of all, right, they made a bunch of requests here, and let's tease these out. But one is stop the evidence from coming in. So sure, we'll have a trial, but all of that is a forced force field that is protecting that information from coming in. Now, the judge said no. They said, okay, well, how about this? If you're going to allow all of that in, the next thing we'll request is an adjournment of the trial date, meaning we don't have to have trial right now because the Supreme Court had already granted certiorari, which means they were accepting the case on February 28th before the trial started. They were agreeing to hear oral argument on April 25th before the trial started. So you could have waited until they decided, and we asked you to do that, and you said no. In a decision in order that was dated on April 3rd, Judge Mercan ruled, incorrectly in our view, that the motion was untimely, right? So the judge had to find another reason. They said, well, you filed this too late, and trial's going to start any minute, and so we have to go, and blah, blah. So in an April 15th pre-motion letter, we explained that this law, this 255.20 from New York law, does not apply to motions to preclude evidence. So the judge relied on some technicality to try to stop the motion from moving forward. But it turns out the judge relied on the technicality erroneously. On April 19th, then, Your Honor, Judge Mercan appeared to agree and advise the parties that the court would rule on presidential immunity objections during the trial based on, quote, your arguments in the letters. That's from a transcript. So the judge says, well, it's untimely. And they say, well, no, Judge, you're wrong. It's not untimely. This is a motion to preclude evidence, which is why we filed it this way. So you're wrong. And he said, oh, okay, you're right. I got the rules wrong. So I will listen to your arguments at trial. Now, during the trial, Mercan noted our objection. Your Honor, here it is. Objection to that, noted. And we re-raised the presidential immunity argument. So we've now made this argument multiple times. Now, at trial and during summations, the prosecutors from Bragg's office, they placed highly prejudicial emphasis on official acts evidence. That's all they talked about, including witness testimony. They specifically talked about events in the Oval Office that Bragg's team described as devastating. All of it's official. They also talked about social media posts that came out during Trump's first term. You see these were government exhibits, 407F, 407I, official acts. You didn't even consider whether he was immune from that or not. We also have the OGE form. That's the Office of Government Ethics form, which came out in March 2018. Who was the president in March 2018? Oh, yeah. And we also have toll records reflecting various calls involving President Trump while he was in office in 2017. All of these are government exhibits. Now, under the Trump case that just came down from the Supreme Court, this official acts evidence should never have been put before the jury. And consistent with arguments that we made before and during the trial, the Supreme Court, as we told you, held that President Trump may not be prosecuted for exercising his core constitutional powers. Can't do it. And he's entitled to, at minimum, a presumption of immunity from prosecution for all his official acts. And he was not afforded that analysis or that benefit at all. The Supreme Court says that the presumption applies, quote, unless the government can show that applying the criminal prohibition to the act would pose no dangers of intrusion on the authority and the functions of the executive branch. And that's high standard, man. No dangers of intrusion, like none. The executive branch is always going to say, oh, if you prosecute us for this, that's going to intrude upon us. So it's really, really powerful. Bragg cannot make that showing here. Sorry, Bragg. Now, moreover, as we also talked about, Trump also forbids the case from the Supreme Court, the immunity case, which is going to be the Trump case, now known as the Trump case, which is presidential immunity. It's a good case. Says that it forbids the use of evidence about such official conduct, even when an indictment alleges only unofficial conduct. And this includes President Trump's tweets and his public addresses. And so for that type of evidence, the Supreme Court remanded to the trial court for evaluation of whether this alleged conduct is official or unofficial. And we'll address that inquiry with respect to the evidence at issue here. But it's clear now, Your Honor, in New York, Judge Juan Mercan on the 34 felonies for false business records, that Your Honor, you may not inquire into the president's motives. And you did that, Judge. And you may not deem an action unofficial merely because it allegedly violates some generally applicable law. Can't do that either, Judge, but you did. And so the verdicts in this case violate the presidential immunity doctrine that has now been dictated by the Supreme Court. And it creates grave risks of an executive branch that cannibalizes itself. And after further briefings on these issues, beginning on July 10th, it will be manifest that the trial result cannot stand. Oh, that's good. Yeah, because that's exactly what happened. And we were here saying saying that, well, first of all, tons of evidence in this trial should have never come in because it was non-credible and not relevant. But the point is, they were introducing stuff all over the place about Trump's presidency. It was official. They didn't do a hearing on this, and this case is not closed. This case is still open, and Trump has not been sentenced yet. So once that document hit, the Bragg prosecutors responded. You can see very short filing. This one came out from Joshua Steinglass. Matthew Colangelo didn't want to write this one. He's still reeling. He's like, what's happening? My whole life is flashing before my eyes right now, because he's Biden's prosecutor who's saying, wait a minute. I thought I had this all in the bag. This was the closest they've come to getting a felony conviction in their rigged prosecutions. Here's what they say from Alvin Bragg's office. On July 2nd, they write back to Honorable Judge Juan Merchan. Honorable says, all right, dear Judge, we're in receipt of Trump's pre-motion letter, the one that we just read, seeking leave to file a motion to set aside the verdict, to get rid of him, based upon the Supreme Court's decision in the Trump immunity case. They say in that letter, Trump requested until July 10th, one day before the sentencing, to submit a memorandum of law in support of his motion. Now, while Trump's letter states that he, quote, does not object to an adjournment of the July 11th sentencing date, so it's okay if we move that, just delete it off the calendar, reschedule it later, no problem. But while he's saying that, his request to file moving papers, right, his actual motion, his memo, on July 10th is necessarily a request to adjourn the sentencing hearing currently scheduled for the 11th. So he's saying, look, he's saying we can file the memo on the 10th and keep sentencing on the 11th, but what the defense is really saying is if you're going to allow him to submit something by the 10th, then the 11th is going to go away. So if he wants that, he says, although we believe Trump's arguments to be without merit, that these verdicts are legitimate and they should stand, the government says, well, if they're without merit, then you should oppose it, right? If they're without merit, why would you not oppose it? But we do not oppose his request for leave to file and his putative request to adjourn sentencing pending determination of his motion. Well, if it's without merit, you should probably oppose it. Well, I don't know why you'd want to continue that out unless it might be with merit. So we respectfully request a deadline of July 24th, even longer than Trump. Trump said, I'll get it to you by the 10th. They're like, how about the 24th? 2 weeks after his requested deadline to file and serve a response. So they want a deadline, all right, 2 weeks after Trump. So Trump could go back out, then they'll have their 2 weeks. I get it. So they'll have their 2 weeks. Trump will have what, his 8 days, then they'll have 2 weeks. They need some time to mull this over. So they allowing this to be moved. The sentencing date, they were so close, man. 9 days from today. So close to getting Trump in Rikers Island. Oh, man. And it got moved again. According to the government, they're having to agree to it. Now, guess what happens next? Judge Juan Merchan, presiding over the Trump trial, comes out and agrees the sentencing on July 11th is adjourned. You see, this came out to counsel via email from Judge Juan Merchan in the state of New York, Supreme Court, lowest level court. He says, all right, dear attorneys in the Trump trial in New York, I write to you in response to your recent communications. He says, I refer specifically to Alvin Bragg's email requesting permission to delay the filing of the sentencing recommendation pending further guidance from this court. So as soon as the Trump immunity verdict dropped, prosecutors, we didn't see this in the public filing, they send an email, Your Honor, we don't really know what to do now since the defense was right and since our prosecution was illegal and unconstitutional. We don't know what to do. What would you like us to do? They also say that Mr. Beauvais sent in a pre-motion letter, which we read, which is trying to set aside the verdict because it's illegitimate, and they requested until July 10th to submit a memo of law. The people sent another letter, July 2nd, the day of this recording, requesting a deadline of July 24th to file and serve their response. So if they grant Trump's July 10th, then they want another 2 weeks. So Bragg's office now requests regarding the sentencing recommendation was already granted. So they're saying, do we need anything? Do we need to do our homework by July 11th? Because remember, in a sentencing, you have three parties. You've got the judge, you've got the prosecution, and you've got the defense. And both sides are going to prepare a sentencing recommendation to give to the judge. So right now, the prosecution's writing theirs, the defense is writing theirs, but you'll also have a third party, typically called probation or pre-sentencing, or different states call them different things, but they do their own independent analysis. So the defendant goes, meets with them, they do a pre-sentence investigation, there's a pre-sentence report, pre-sentence interviews, all the things, and then this party also gives a recommendation to the judge. So the prosecutor is going to ask for the max, the defense is going to ask for the minimum, and the third party, the independent independent analysis, so-called, who still works for the government and gets paid by the government, is going to make a recommendation to the judge based on the following interview that they conduct. But now Bragg is saying, we don't know what to do on this, so can we have more time? And the judge has now granted that. He says, all right, so this is granted, and Trump's request to also file their memo, not the sentencing recommendation. So this is a sentencing recommendation. We're not talking about that. We're now talking about a memo on whether or not the case essentially and the verdict should be set aside entirely. So the sentencing recommendation was granted, so the government has more time. Trump's request to file his motion by July 10th is granted, and the response deadline is also granted, so July 24th, which means we're not going to have sentencing there on July 11th. Man, Democrats, so close yet so far away. Trump was going to go into custody on July 11th. Not happening. The sentencing date on July 11th is therefore vacated by, and watch this, the court's decision will be rendered off calendar on September 6th, which just happens to be a great day here. And the matter is adjourned to September 18th, 2024 at 10 a.m. for the imposition of a sentence, if such is still necessary, or other proceedings. Oh, man! See that right there? If such is still necessary. And guess what? It's not gonna be, because Trump has immunity. And you just admitted a bunch of evidence that should never have been admitted. And Trump told you it shouldn't have been admitted. And you had all the opportunity in the world, Judge Merchan, to allow the matter to play itself out through the courts, through due process of law. But you didn't allow that to happen. And now the Supreme Court corrected the record, and you have to comply, and he's not going to be able to do that. Man, this sentencing may not be necessary at all. Why would you need a sentencing for a totally illegitimate case? You don't. So very truly yours, Judge Juan Merchan, if such is still necessary. Oh, bummer for them. This is another thing. They don't want any press there. So this is another filing from Matthew Colangelo. Before the immunity decisions dropped, they had sentencing scheduled, and the press wanted access to this. Okay, so this letter from Colangelo is saying several news organizations wanted audio-visual coverage of this thing when it does go to sentencing, and we don't want that at all. Saying civil rights law bans coverage, and by its terms, it's very easy to understand why cameras are prohibited. And so the people know that although Trump has stated he takes no position on this, this would create a circus-like atmosphere during sentencing. And so we recommend that there are no proceedings. With minor modifications, everything was perfect, and it's your discretion, Your Honor, to conclude no changes are appropriate. And so we don't want any public media in there during the sentencing, which has now been lifted and moved. So they're in big trouble. They don't know what they're doing over there. Even Rachel Maddow is having a meltdown, saying now this immunity decision's out, he's not going to be a convicted felon. We're going to lose everything, and we're all going to die.
And this is a president who has activated pro-Trump paramilitary groups that, wear insignia and T-shirts and hold placards celebrating literally right-wing death squads, right? This is a president who has talked about absolutely using the Justice Department to go after his rivals. This explicitly immunizes anything the president wants to do through the Justice Department, but all but explicitly justifies anything the president wants to do, full stop, to anyone. And that is as serious as it gets.
Serious as it gets. Rachel Maddow. So they're all under attack now, moving forward. It was a really good day for Trump. You can tell because they're so upset about it. Trump's team sends a letter over to Judge Merchan, and he basically grants it. That very important sentencing that they were all scheduling their slumber parties over are now going to have to be canceled. Sorry, Liz Cheney, Nancy Pelosi. Reschedule and have a new date on the calendar. We'll see if it happens. Don't hold your breath. All right, my friends, we're going to continue to cover this trial as it continues. We've got a bunch of new filings obviously coming up. Trump's got a deadline, July 10th. Government will be responding. We'll read through the filings here. Thank you for subscribing wherever it is you're watching this. Thanks for sharing our channel with a friend or family member so that they can join us as this litigation continues to unfold. We'll look forward to seeing you back here and on our next video, which is all about what's happening with Jack Smith and Judge Clarence Thomas in his concurring opinion saying that Jack Smith is illegitimate. So we've got that video coming up right here, and we'll see you over there on the next one.